Thompson, you again, I think, for this.
I'm afraid so. State immunity. Two preliminary observations before we turn to the substantive arguments. This issue only arose for the first time in the Court of Appeal just before the mortgage appeal, when the respondents amended their notice of appeal to ask for costs against the government of Indonesia, or the Republic of Indonesia, and in the alternative applied to have them joined as a party. Now, that's had one practical effect, which is because it was raised only at that stage, no evidence was directed to this issue in any of the courts below. And as we will see later, that may be of some significance in the context of the allegation that state immunity was waived. But secondly, obviously, this allegation and the finding of the Court of Appeal have some considerable impact on mutual assistance for countries who are requesting assistance of particularly Jersey. And if the reasoning holds good, it will happen with other countries. One can well imagine a smaller nation, which has had a corrupt clique in power for a number of years, who've emptied the treasury, and the incoming government have to try and trace the funds, and there's no money in the treasury, and then they come to litigate and find that they too face the risk of costs. So it's of some practical significance.
Those two be in just the same position as most litigants in that case, so I don't think the sympathies argument's going to go very far. It's just a question of law, isn't it?
Well, it is a question of law. Can I then turn to the... apologies. Can I turn then to the Court of Appeal judgment in the matter, just to highlight the way they decided the case? So it's electronic bundle, page 382. Paragraph 58, if I can just... So paragraph 58 recites the application that had been made, and that an order for costs on the standard basis should be made against the Indonesian ministry. And then it's 59, where the relevant statute is set out as a result of the provisions of the 1999 law and the proceeds of crime enforcement confiscation regulations. Provisions have been made for the representation of overseas authorities, and we'll come back and look at that. The court then goes on to deal with the rival submissions, which in view of the time we have, I'm not going to go through. They're there for all to see. And the actual decision is further down. Discussion, paragraph 82, page 387. So what the court said was this: in our judgment, the determination of the issue turns upon the appropriate characterization as a matter of law of the request made by the ministry, taken together with the agreement of the Attorney General to make the applications which have led to these proceedings. If the proper characterization is that the Republic of Indonesia, through the ministry, has instituted the present proceedings, it follows that it is submitted to the jurisdiction of the courts of Jersey and is not immune from liability. Then they deal with the 1978 State Immunity Act, which has been applied to Jersey by an order with the necessary modifications. But the important part is this: the order in the first article states a state is immune, that's the general rule, but then the exceptions come. 2.1, a state is not immune as regards proceedings in respect of which it has submitted to the jurisdiction of the courts of the bailiwick. And then there's another exception under 3, which is this: a state is deemed to have submitted, A, if it has instituted the proceedings. And then the final point, Article 18, comes from the United Nations Convention on Transnational Crime. This is one of the submissions that was made. I went through this yesterday, found the widest possible measure, didn't take up time with that. They go on to say the request is obviously made for the purpose of recovering property, and they're then at the top of page 390 set out the law, which is in Article 6. In any proceedings in the Royal Court under that's the 1999 Law of Proceeds of Crime Law, the government of a country or territory outside Jersey shall be represented by the Attorney General. 2, in any such proceedings to the Royal Court, a request for a country or territory outside Jersey shall, unless the contrary be shown, constitute the authority of the government of that country for the Attorney General to act on the government's behalf. As then follows paragraph 90, having regard to that, they say this: in our judgment, it is all but incontrovertible that the commencement of this process should be characterised as an institution of proceedings by the Ministry, albeit with the assistance of the Attorney General. As we've indicated, the Attorney General could not have instituted such proceedings on his own mere motion or caprice. Further, as the conventions make clear, whilst mutual legal assistance may be refused, the relevant circumstances are restricted, as otherwise the likelihood of true mutuality could readily be defeated. And that really is the core of the reasoning of the court. Now, 3 observations that the appellants would make. 1, that would seem to be contrary to the spirit of the various conventions. We cite, for instance, the Palermo Convention, which, along with a number of them, sets out the general principles, but it's Article 4 of the Palermo Convention. This wording appears in a number of them. It's 3338 in the electronic bundle, Article 4, which deals with states complying with the convention. And it's Article 4, which is one of the important articles we would submit. Article 4, protection of sovereignty. State parties shall carry out their obligations under this convention in a manner consistent with the principles of sovereign equality and territorial integrity of states, and that of non-intervention in the domestic affairs of other states. And 2, nothing in this convention entitles a state party to undertake in the territory of another state the exercise of jurisdiction and performance of functions that are reserved exclusively for the authorities of that other state by its domestic law. Well, the domestic law does reserve the right to the Attorney General. So the first point we'd make is, if you look at the statute in the context of international law, it seems that the principle of the protection of sovereignty is a very important feature of the conventions. Secondly, in its decision, and this is unfortunate, the Court of Appeal has not cited a number of authorities that deal with this issue. Now that occurred probably because one of those authorities, which we put in our bundle, is really quite hard to find. It's only reported in the international law reports, nowhere else. And secondly, of course, this was all dealt with by written submission rather than oral hearing. Now, I'm not complaining about that, but that may explain why that happened. And so far as we are concerned, then there is one authority which, in our submission, is directly on point. That is, whether a state, by requesting assistance, has initiated the proceedings. It's Propane, Finance and Sing.
Sorry, I missed what you said.
authority for the proposition.
Yeah, sorry, it's just the name of the case.
Propend Finance against Singh, S-I-N-G.
Did the Court of Appeal find that the Indonesian authorities were party to the proceedings or not? Did they find that they were party?
Yes, they did.
They did find.
Yes. They had to be parties for the costs order to be made against them. The only other way would have been to apply to join them, which of course would have been met with the sovereign immunity doctrine. So once the court decided that sovereign immunity didn't apply, they were a party, represented, it's said, by the Attorney General.
Propend Finance and Singh?
Yes.
Where is that?
That's 2972 is where it starts. It's probably just as well to look at the head note because that sets out the circumstances. So it was first of all decided by Mr. Justice Laws and then went to the Court of Appeal later on. In August 1993, the Attorney General of Australia made a request to the Government of the United Kingdom, pursuant to a scheme of mutual assistance in criminal matters within the Commonwealth, the Harari scheme, to seek a court order to search for documents relating to an investigation being conducted by the Australian Federal Police. The investigation concerned the plaintiff company, Propend Finance Pty Limited. In response to this request, the United Kingdom Home Secretary issued directions to the Metropolitan Police in London. Acting under these directions, officers of the Metropolitan Police applied for search warrants, which were issued by Judge Goddard at the Central Criminal Court. The first defendant, Superintendent Alan Singh, who was an officer of the AFP and an accredited diplomat with the role of police liaison officer at the Australian High Commission in London, gave evidence at the hearing at which the warrants were issued. The following day, the Metropolitan Police seized documents from the premises of a firm of solicitors and a firm of accountants in London. These documents were subsequently handed by the Metropolitan Police to the first defendant, who took them to the premises of the Australian High Commission. The plaintiffs sought judicial review of the decision to issue the search warrants, and on the 29th of October applied to the High Court for an interlocutory injunction restraining the first defendant from dealing with the documents. At the hearing of the application for an injunction before Mr. Justice Potts, the first defendant gave an undertaking that neither the documents nor copies thereof would be removed from the jurisdiction of the court or from the High Commission, and that copies of the documents would not be transmitted by fax. The decision to issue the search warrants was subsequently quashed. And this is where this becomes relevant. Several months later, the plaintiffs discovered that the first defendant had sent extracts from the seized documents to the headquarters of the AFP in Canberra shortly after giving the undertaking to the court. The plaintiffs alleged that this communication was in breach of the undertaking and instituted proceedings for contempt of court against the first defendant, who by then had completed his appointment in the United Kingdom and returned to Australia, and also, it seems, against the Commissioner of the Australian Federal Police, who was sued as representing the AFP. This is the issue. The defendants maintained that the court lacked jurisdiction because the first defendant, that's Mr. Singh, was entitled to diplomatic immunity, and both defendants were protected by state immunity. And so the first issue that had to be decided was Mr. Singh, and Mr. Justice Laws, the first defendant, was entitled to diplomatic immunity, and the court therefore lacked jurisdiction over him. The Commissioner was not entitled to state immunity. Now that finding in relation to the Commissioner was later overturned by the Court of Appeal. But there are a number of issues which I don't want to take you to, but it's D over the page on 2974 is where the relevant passages start. This is what Mr. Justice Law said. If the first defendant had initiated the proceedings by obtaining the search warrants, he would have been deprived of immunity by virtue of Article 32.3 of the Vienna Convention in the subsequent proceedings in which he'd given the undertaking. That would have been so, notwithstanding that the two sets of proceedings were separate and had taken place before different courts. But of course, they were linked. And then that was, if we scroll down, we see the reasoning. And if we, for that, we have to go to 2988. Where the issue about initiating the proceedings is dealt with.
Where do you want us to pick it up on that page?
Towards the bottom, if I may. It's just...
So you're relying on an analogy with
Yes.
similar provisions in relation to
In the
diplomatic.
Vienna Convention, it doesn't say institute; it says initiate.
Right.
There, but it's a very similar point. And in fact,
The issues of law begin on
it's Article
2988.
32, which it's the wrong. It's Article 32 set out on page 2991, which is the relevant article, which is, see, it says the immunity from jurisdiction of diplomatic agents may be waived by the sending state. Waiver must always be express. But then it's 3. The initiation of proceedings by a diplomatic agent, immaterial words are missed out, shall preclude him from invoking immunity from jurisdiction in respect of any counterclaim directly concerned with the principal claim. I don't need to go into it, but it was decided that the appearance before Potts J was in effect a counterclaim within the meaning of this article. And therefore, the issue was, what was the effect of applying for the search warrants? So we go to page 3000. After the rival submissions are set out, which I shall not burden you with. It starts where a paragraph saying the real question. And then goes on from there. So page 3000 is where the question is posed, then it goes over onto page 3001. So the real question on this part of the case is whether the first defendant can be regarded as having initiated the Old Bailey application. In form, at least, it was made by the Metropolitan Police, and by Section 7.4 of the Act, which I've not set out, could not lawfully have been made but for the Secretary of State's direction. So, rather as here with the appearance, it can only be made by the Attorney General in this case. And it said, in giving the direction, the Secretary of State, of course, acted in pursuance of the request made on the 27th of August by the Attorney General of Australia, and did so in the light of the understandings in the Harare scheme. I don't think I need to take, it hadn't actually been incorporated into English law, it says. And then if we look towards the bottom, after dealing with the outline of the scheme, he says this: if the Metropolitan Police were the applicants before Judge Goddard, the first defendant, as a matter of fact, certainly took over the substantive conduct. The first page of the transcript shows him sworn as a witness after short initial exchanges between the judge and D.C. Fryer. Thereafter, the whole hearing was taken up with what he had to say in answer to questions from the judge. Apparently, she put 2 queries to D.C. Fryer, and the rest of the hearing seems to be conducted by the Australian liaison officer. There is the argument. Mr. Plemming, over the page, seeks to persuade me that the first defendant should be treated as having initiated the Old Bailey application. It's put this way in his principal skeleton. It is submitted that the second defendant and or the Commonwealth of Australia initiated the proceedings through the letter of request asking for the English courts to issue process to obtain the documents in question. The instant debt and new proceedings and judicial review proceedings were in substance, in fact, a challenge to the process initiated by the second defendant. The first defendant, that's Mr. Singh, was not only a party to that initiation of process, but actively contributed in asking the Secretary of State to include other matters coordinating and making the application to Judge Goddard. And then that was the submission, and Mr. Justice Law's response is, the first difficulty with this, in my judgment, is that it is impossible to regard the making of the request as the initiation of proceedings. Given what I've said about the Harari scheme and the role of the Secretary of State, the request cannot sensibly be treated as anything more than what it purported to be, a request for assistance. And then there's another difficulty which isn't relevant, which is following the initial request, there was an enlargement of the material which was to be sought. Mr. Plemming's real case against the first defendant on this part of the argument rests crucially on his participation in the Old Bailey application. As regards that, it is no accident that the Metropolitan Police were the applicants before Judge Goddard. No one else had any title to make the application, since the power to make it was wholly grounded in the Secretary of State's direction, which had been issued, and only issued to the Metropolitan Police. It is to be noted that the plaintiffs themselves, in their grounds for judicial review against the Secretary of State, described the matter this way, and that's then set out. And he concludes by saying, now I can conceive there may be circumstances in which a diplomat is deprived of immunity under Article 32(3), though he's not in formal or procedural terms the plaintiff or applicant in the relevant proceedings. And I'm afraid my printing is ever printed. There might be, he says, and I can't read that, I'm afraid, proceedings are brought by another on his behalf in which he is later personally impleaded and is unable to invoke immunity by reason of Article 32(3, by virtue of what had gone before. But however that may be, this is not the case. First, the Metropolitan Police were not a mere nominee. They had a substantive responsibility as regards the matter in which the Secretary of State's direction was to be complied with, as is shown by the fact that on the 17th of March of 1994, the Divisional Court ordered them to pay half the costs of the judicial review proceedings. Secondly, so far as it might be said that the Metropolitan Police are to be regarded as having acted on behalf of anyone else at the Old Bailey hearing, which in itself is a proposition not without some difficulty, they were clearly not acting on behalf of the first defendant. He had no personal axe to grind. His part was, of course, to further the application for the warrants. The interest in obtaining them was for the Australian Federal Police and no doubt the Australian DPP. And then he says, as a result, I hold that Article 32(3 has no application to the case, and I reject this head of Mr. Plemming's arguments. Now, of course, in this case, we draw a parallel. The Attorney General receives the request. He has to look at that request and decide whether he will act on it and make an application to the court. And although it's perfectly true, there are grounds on which he may not refuse to act on a request. Plainly, if he gets a request and it doesn't comply with Jersey law, he can say, I'm not going to institute proceedings. Secondly, he may take the view that there is no prospect at a later stage of the proceedings of the confiscation order being registered. And again, he has to make a decision on that in his own right. He is not simply an agent of the requesting state. He is the senior law officer in Jersey and has his own public duties and responsibilities. So we would draw the analogy there that he's not just a nominee for the Republic. that was the first instance decision, and there were other issues as well about waiver and so on, which I'm not going to go to. We then have to go to the Court of Appeal, who had to deal with it. So 3014 is the Court of Appeal judgment. Apologies, I typed in the wrong number. This is what the court decided, so go through the facts again, which I don't need to take you to page 3020. In fact, actually, because it's relevant, we might just go back a bit, because this issue arises later on here, page 3017. This deals with the waiver point about the waiver being expressed. For the plaintiffs, Mr. Plemming submits that there has been a waiver of immunity with respect to the superintendent. He accepts that to be effective, a waiver must be first expressed, second made by the head of mission or any person for the time being performing those functions. Of course, this is the point that's going to arise later, and which is why I said no evidence was directed to this issue, where it says, and third, must be made in full knowledge of the diplomatic rights. And then the issue of the undertaking in front of Mr. Justice Potts is canvassed. And in the end, that head of the claim was rejected. If we then go to page 390.
On behalf of whom was or by whom was the undertaking given?
It was given by Mr. Singh, the first defendant. The issue, which I haven't gone into, is whether when he gave that undertaking, he had gone back to the High Commission to get authority to give it to Mr. Justice Potts, and there was a huge conflict of evidence over that. In the end, Mr. Justice Laws couldn't resolve that, but decided that he hadn't, in fact, got the authority. That was an issue of fact that was canvassed. But that's why it's important, because you have to, for the waiver, have to have full knowledge of the rights you're waiving. And the finding of fact by the judge was, you couldn't say that was the position.
And can I ask, how was notice given to the state of Indonesia of this application?
I think the first we knew about it was when there was the application to amend the Court of Appeal Notice of Appeal to add in the Republic to be liable for costs.
So how was that served on the Republic?
Well, it wasn't formally served at all.
Right.
Oh, well, sorry, I apologise. My little friend was there, I wasn't. They certainly knew about it anyway. I'm not... We'll check that. We may have got that wrong, but up until that point, no documents are being formally served through the court.
Yes, do go on.
So, having dealt with waiver, the Court of Appeal then go on to deal with the same point Mr. Justice Laws did, looking at whether what had happened constituted the initiation of proceedings. Mr. Plemming, he says, submits that the Commonwealth of Australia initiated the proceedings by the letter of request to the Government of the United Kingdom for assistance pursuant to the Harare Scheme, while the Secretary of State issued a direction to the Metropolitan Police in accordance with the request. The Superintendent was a party to the initiation of the search and seizure procedures. The Metropolitan Police, it is submitted, had no direct interest in the application other than as a matter of international cooperation and acting as a conduit for the Australian authorities. It was the Superintendent who gave evidence before Judge Goddard And effectively, it was his and his government's application. The only way the plaintiff could defend themselves against the consequences of the search warrant issued by the judge was by the application to Mr. Justice Potts, and the application therefore was a counterclaim within the broad meaning of that word in the article. And then they cite authority for that. And then this, 659 in the report. In our judgment, there is no escape from the conclusion reached by the judge that the proceedings were initiated by Detective Constable Fryer of the Metropolitan Police. The application was made by him pursuant to the Police and Criminal Evidence Act and the relevant mutual aid assistance statute at the time, the Criminal Justice International Cooperation Act, 1990. And then the judge sets out the procedure.
So they sort of impliedly rejected any suggestion that by using the word initiating proceedings rather than the word we have here, which is instituting,
yes,
that you could look a step back, as it were,
yes,
as to what was it that triggered
yes,
the bringing of the proceedings by the Metropolitan
yes,
Police.
yes, that seems to be
yeah.
Reasoning behind it. Then it went on to deal with other issues which no doubt are interesting, but in the interest of time I'm not going to deal with. So that was the main authority to which we draw a parallel, bearing in mind the function of the Attorney General. Secondly, we draw from that the mere fact that a police officer gives evidence in proceedings does not in itself mean that obviously he's initiated those proceedings or, in this case, instituted them. What happened in this case happens in every request for mutual assistance. The Attorney General has to have some evidence to put before a court, and so naturally someone from the requesting state will provide an affidavit or a statement setting out what the case is all about. And that's what happened in this case. There were a number of affidavits sworn for various stages of the proceedings.
It's quite a strong decision in the sense that the court might say he gave an undertaking to the court, yes, and it was on the strength of the contempt enforceability of that undertaking, yes, that we gave the relief.
Yes.
But they didn't say that amounted to submission to the jurisdiction.
No, the reason was, of course, that there's a case called R.V. Mallon, which is that the diplomatic agent himself does not have the authority to waive immunity. It has to come from authority. And that was the factual issue that Mr. Justice Laws sat on and decided that there was no sufficient evidence to show that Mr. Singh had the authority to give that undertaking and waive state immunity.
You also rely on the statement to you 3020 that neither the superintendent nor his government had power to make the relevant application.
Yes, that's right, because under the procedure they couldn't go to court and make the application. It had to be done through eventually the Metropolitan Police. Right. Rather belatedly instructed Mr. Barker QC for the contempt proceedings. But that's the parallel we would submit. Now that philosophy that merely initiating proceedings doesn't amount to a waiver, other jurisdictions have touched on this issue, although concede immediately, obviously not quite the same, but it's the philosophy. Bear in mind the time. Can I just go to one of those authorities and then one that's mentioned in it? There's an American case called Blacksland, which is 2539 in the bundle. 539. Now, the Americans don't have quite the same system in their statute as we do. There's no specific provision about initiating proceedings, but they have a similar concept of something called an implied waiver under their Foreign Sovereign Immunities Act. And the question in this case was whether the authorities had impliedly waived their immunity because of the initiation of, in this case, extradition proceedings. So if we just look at the head note and then one of the relevant parts of the judgment. So the extraditee and his wife brought state court action against inter alia 2 instrumentalities and 2 employees of the Australian government, asserting claims for malicious prosecution, abusive process, intentional infliction of emotional distress, and so on. The defendants removed the action, and that's then took it to a higher court because of the issue, to dismiss it on sovereign immunity. The United States District Court for the Central District of California denied the motion as to the Australian instrumentalities, but granted the motion as to the employees, and then that led to the appeal to this court. And then similar structure. The American system is that, as with ours, immunity subsists unless there's an exception under the Act. And so the first part of the judgment's taken up with that issue. Page 2539 is the kernel. The allegation was that by pursuing this extradition request in America, having the plaintiff arrested and remanded in custody, and then later proceedings not taking place in the proceedings took place in Australia, but he was acquitted. He then brought these civil claims. To get the claim home, he had to show there was no sovereign immunity attached to the actions. And this is what the court said, or rather the summary is, Australia did not impliedly waive its sovereign immunity under the FSIA by seeking and obtaining the American resident's extradition when Australia itself did not apply to the US courts for insistence, but instead invoked its rights under the extradition treaty by applying to the executive branch of the US government. And nothing in the extradition treaty indicated an intent to waive sovereign immunity in extradition proceedings. And therefore, the Foreign Sovereign Immunities Act barred the plaintiff's claims. And it went on to say it did not matter that Australia's use of the extradition proceedings was fraudulent. So there was plain authority, we say, for a similar approach, again, not identical, but a similar approach taken by the American authorities. And the third case, which indicates...
Then at 10, just below that, they say foreign countries' use of United States courts can be sufficient to trigger.
That's a case called Siderman. But 2 points, it was rather interesting. Siderman was a court-to-court request. So it was a court in Argentina sent a letter rogatory to a court in the United States. But the court found in Siderman that the Argentinians' motive in doing that was to persecute Mr. Siderman, whose property had been seized in Argentina, his family imprisoned, and so the allegation was the use of the court system in the United States was an extension of the persecution by Argentina. In Siderman, the court did not definitively decide that that was a waiver because it sent it back to be reconsidered. It said it was capable of being a waiver in those circumstances. It's not authority for a general proposition that a normal letter rogatory would amount to a waiver. But in the peculiar circumstances of that case, yes, it was capable of waiving immunity. And then the third case, which I was going to briefly refer to, is a Canadian case called Schreiber, which is at 3135, judgment, rather than part of the judgment. It's a similar case.
Is this another extradition case?
This was also an extradition case, very similar allegation that there was effectively a false application. It led to the plaintiff being imprisoned, and he was claiming damages for personal injuries as a result of the extradition process.
And which court is this?
This is the Canadian Supreme Court, Supreme Court of Canada. In fact, page 3127, you see the introduction, which sets the issue. It says, this appeal pits the interests of an individual wishing to sue a foreign state in Canadian courts against the state's enjoyment of sovereign immunity to preclude such actions. And then he deals with the principles of the international law, sets out the facts, which I haven't got. Then the state immunities provisions are relevant, they're set out. If we see on page 3129, it says this: except as provided by this Act, a foreign state is immune from the jurisdiction of any court in Canada. For one, a foreign state is not immune from the jurisdiction of the court if the state waives the immunity conferred by subsection 3.1 by submitting to the jurisdiction of the court in accordance with subsection 2. And you can see very similar wording to the one we looked at in the diplomatic convention. In any proceedings before a court, a foreign state submits to the jurisdiction of the court where it B, initiates the proceedings in the court, or C, intervenes or takes any step in the proceedings before the court. And then it gives the common exception that that doesn't apply if the only step taken is to claim immunity. So it's very similar to the structure of our Act.
And you say that intervention or step taken are technical things rather than just a sort of normal meaning of that.
I was going to look at the fourth case at a moment, moving to that side. But Mr. Schreiber, as I say, sued in Canada. It's paragraph 24 of the judgment.
Page
3135.
Okay.
Again, there was an effort made to find some other exception to sovereign immunity, but it failed. It's paragraph 19, in fact, on that page, 3134. This is how the case was put. The appellant submits that Section 4 of the State Immunity Act reflects the policy that if a foreign state invokes Canadian processes, it cannot claim immunity from later Canadian processes concerning the same matter. The appellant's argument under the Section 4 exception is twofold. First, the appellant argues that the exception in Section 4.2b applies because Germany initiated the proceedings in a Canadian court. Although the appellant issued the statement of claim, he submits the proceedings were in fact initiated by Germany's request that the Canadian authorities go before the Ontario Superior Court of Justice on behalf of Germany to arrest and imprison him. And then the judge sets out the provision we just looked at. Germany responds that it did not submit to the jurisdiction of Canadian courts. The only step taken by Germany in these proceedings has been to bring the motion challenging the court's jurisdiction that is the subject of the present appeal. In Germany's view, that step may not be construed as a waiver of sovereign immunity under express wording, and then they go into the taking the steps in the proceedings. Germany submits that the extradition proceedings initiated pursuant to the extradition treaty and the present civil action for damages are separate legal actions. Any step taken in one does not amount to a step taken in the other. Then further arguments, if we go. And then the judge says at the bottom, 3135, I agree with the submissions of both respondents with respect to the interpretation of section 4.2b. In particular, it is my view that Germany did not initiate the judicial proceedings as its request to arrest and imprison the appellant was made to the executive branch of government pursuant to the extradition treaty. It was the Minister of Justice who authorised the Attorney General to apply for an arrest warrant. Then he goes on to...
well, there isn't that system here, is there?
No, it's not, but it's the analogy we rely on. I mean, obviously, the Attorney General gets the request, as I say. He has to look at the request, decide whether to act on it. And only if he decides to act on it are the proceedings taken. So there is a barrier, if I can put it that way, between the foreign state requesting it and any proceedings in the court. So there is a loose analogy. So those were the three cases. Can I deal with interventional step and the proceedings to answer the point? That's the case of as is, which we've set out in some detail. It's the Republic of Yemen against Aziz. It's in electronic bundle 3103. This arose in the context of an employment tribunal case, and basically the applicant was a member of staff at the London Embassy of the foreign state. He was dismissed, and therefore he brought proceedings in the industrial tribunal against his employers, who were the Republic of Yemen. And then if you look at the head note as to what happened, a notice of appearance and grounds of defence were served by solicitors, purportedly on behalf of the employers, before the employment tribunal, counsel for the employers conceded that the entering of the notice of appearance constituted a step taken in the proceedings, but the employers, with the meaning of section 2.3b, was within 2.3b, but contended that this had been done in ignorance of facts entitling the employers to immunity, so that by virtue of section 2.5, the employers should not be deemed to have submitted to the jurisdiction of the tribunal. Then the tribunal, having heard that, found in favour of the issue and found that there had been a waiver. There was then appealed to the Employment Appeal Tribunal on the ground that they'd not taken a step in the proceedings since, and this is the point I was making, the entering of the notice of appearance had not been authorised by the ambassador. The Employment Appeal Tribunal then admitted evidence from an attaché at the embassy to the effect that he had instructed the solicitors, believing that the Employment Tribunal was a conciliatory body only, and from the ambassador to the effect that although he'd been aware that the attaché had had dealings with the solicitors regarding the applicant's case, he'd not authorised the attaché. And there was then finding 1 by the Court of Appeal, which I don't need to, but it's finding 2. Allowing the appeal, so there could be no submission to the jurisdiction unless it was made by a person with knowledge of the right to be waived and the authority of the foreign sovereign, that to constitute a step taken by state in proceedings under section 2(3)b of the State Immunity Action had to be taken by a member of the diplomatic mission or solicitors instructed by the mission, had to be taken with the authority of the head of mission or the person for the time being exercising his functions. And so if we go, they sent it back for further fact-finding, but the important part is on 3115, where they considered an important earlier case, which I don't need to go to because the relevant passage is set out in this judgment.
So which paragraph?
It's the paragraph just... in fact, it starts on 3114. It's paragraph 41, looking at the earlier case, so 3114. It refers to a case called Bacchus SRL against Servicio Nacional del Trigo. Defendant's organisation carried on business from Spain and was sued in England for damages for breach of contract. Appearance was entered by their solicitors in London and a consent order made for security for the organisation's costs. These steps were taken on the instructions of the head of the organisation, Mr. Cavero, who was a senior civil servant, but without the Ministry of Agriculture knowing of them. 18 months after the writ was served, steps were taken to stay proceedings on the ground that the organisation was a department of the Spanish Ministry of Agriculture. It was held in this court, that's the Court of Appeal, by a majority first, that the defendants were a department of the state of Spain and entitled to claim immunity, and secondly, that there could be no submission to the jurisdiction unless it were made by a person with knowledge of the right to be waived and with the authority of the foreign sovereign. And then on this second point, they refer back to the judgments in the case. And paragraph 44, I'll just ask perhaps to read.
Yes. Now, Mr. Thompson, you've reached the limits of your time. Was there anything else that you need to mention to us before
2 points.
closing?
It may be suggested that appearing as a witness, in other words, because affidavits were put in the proceedings, that made them a party to the proceedings and therefore waived state immunity. First of all, there's evidence, a case called Gleeson and Whipple, it's in our submissions. Merely appearing as a witness does not make you a party to the proceedings. But secondly, the United Nations Convention on State Immunities, its Article 8(2), says that a state does not submit to the jurisdiction merely because a party of the state is called as a witness, which is what's happened here. So our submission is, as it were, threefold. First of all, we say, look at the international conventions, which emphasize preserving sovereign integrity, state immunity. Secondly, there is authority to say that merely because someone has initiated proceedings on behalf of, as this statute says, a foreign state, does not mean the foreign state initiated the proceedings. And thirdly, in any event, if it's suggested that somehow in the proceedings the state has waived it, has to be done with knowledge of the right to be waived. That's sovereign immunity being lost. And there is no evidence in this case that that happened. The mere fact that affidavits were submitted is insufficient. We've set out in full the submissions, but gosh, in short measure, those are my submissions. Thank you.
Yes. Thank you very much, Mr. Cousins.
Something that my friend has not taken you to, however, is the whole statutory underpinning of his authority to be here. May I do that? And ask you to look at go back 24 hours to the regulations.
Well, that's what this appeal seems to me at least to turn on.
Well, my Lord, we respectfully agree, but there is more. First of all, I won't actually go to the regulations, the very first, because I want to draw your attention to the wording of the modified law itself. Give me just a moment while I reach it.
May I just point out I didn't have the regulations because they're set out in the Court of Appeal judgment, which I went to.
Well, yes. If you go to page 2049, where the modified law appears. No, I'm sorry. Do forgive me. That's not.
Can you just explain to me why on that page it doesn't have the words on behalf of the state on page 2049?
2049.
16.1 there just
Yes.
says made by or on behalf of the Attorney General. How does that relate to the one that you rely on that's
Well,
had
because
further words added on behalf of the foreign state or something?
I think I can answer that fairly straightforwardly.
Yeah.
2049 is the original proceeds of crime law, which didn't involve foreign states.
I see.
Whereas when we get to the proceeds of crime law, and we look at says E there, in Article 16, these words were introduced quite deliberately because the representation is going to be of a foreign state, not the government of Jersey. So that I hope, is a short but accurate answer to that question. So we first of all have a statutory basis in the modified law itself.
I'm sorry, can you give us the page?
Yes, of course, 2122. And this isn't one of the typos. So we have that basis for it.
Whereabouts on 2122, sorry?
2122 at Article 16.1.
This is the modified law.
This is the modified law, yes. Now,
So you referred to the words on behalf of the government of a country or territory outside Jersey.
yes, I do.
And the written case on behalf of the appellant is, those words must be read as at the request of.
Well, my Lord, I acknowledge that, but I want to go to the regulations because they in my submission, they just put the matter beyond any doubt at all.
Just before we move away from this, what's the point of saying an application made by or on behalf of the Attorney General if it's not the Attorney General who is the person making the application? If it was the government itself that could make the application, you don't need the Attorney General to be interposed here.
Well, my Lord, it would assist, I would submit, in answering that if I could take the court to the regulations, which actually...
Resisting that temptation just for a moment or two. An application made on behalf of the Attorney General, on behalf of the government. Does that make sense?
Well,
Because if you take out, it's an application made, and there's alternatives, on behalf of the Attorney General, on behalf of the government. Made by the Attorney General, but I have some...
Well, I suppose made by Mr. Thompson on behalf of the Attorney General, on
Yes.
behalf of the government.
I would respectfully adopt that construction. It's to be made, in other words, by counsel, but it has to be, in this case, the Attorney General. It is the Attorney General who's fixed with the responsibility for doing it. And if more guidance is needed, we get it from the regulations themselves at page 2109. And it's to be remembered that the modified law takes effect pursuant to these regulations. Paragraph 5, 2109. Evidence as to appropriate authority of a country or territory outside Jersey. A certificate by the Attorney General stating that an authority specified in that certificate is the appropriate authority of a country or territory outside Jersey for the purposes of these regulations shall be sufficient evidence of that fact. It's common ground that the attorney filed such a certificate.
Right, but he has to do so in order to bring himself within Article 16.1, doesn't he?
He does.
But so I'm still not following why that makes it an application by or initiation of proceedings by the state itself.
Because he represents Indonesia, and that is stated clearly in Regulation 6, representation of overseas governments in royal court. In any proceedings in the royal court under the law, the government of a country or territory outside Jersey shall be represented by the Attorney General. This ties in with the Article 16 point. 2. In any such proceedings in the royal court, a request for assistance sent to the Attorney General by the appropriate authority of a country or territory outside Jersey shall, unless the contrary is shown, constitute the authority of the government of that country or territory for the Attorney General to act on the government's behalf. It could not be clearer.
Well, I'm not sure about that, because again, just for the Attorney General to be within Article 16.1, he needs to be able to show, for the purposes of the operation of that law, that he is acting in whatever is the relevant sense on behalf of the government of a country or territory outside Jersey.
Yes.
So this provision seems to be aimed at him being able to satisfy that part of his own authority to act for the purposes of Article 16.1.
But he's provided the certificate and he has appeared.
Yes.
There is no Jersey. Indonesia cannot be represented on any other basis.
Right. But it still seems to fall short, if I may say so, of establishing that Indonesia has initiated the proceedings for the purposes of losing immunity. We know from Article 16.1 that the Attorney General is the person that initiates the proceedings. Since otherwise, why refer to the Attorney General? But he can only do so if he is doing so on behalf of a government of a country or territory outside Jersey, reading it.
My Lord, yes.
This is how he establishes that he's clothed with that ability for the purposes of Article 16.1, isn't it?
If he appears on behalf of the government of Indonesia in the same way that a solicitor appears on behalf of his client in proceedings, then the party instructing is a party to the proceedings.
But is he appearing in the same capacity as a solicitor? Isn't it from Article 16.1, page 2122, he himself, the Attorney General, who makes the application, but in order to be able to be in a position for him to make the application, certain processes have to have been gone through for him to be able to bring himself within that provision.
My Lord, of course, but it's no different from a solicitor being instructed by a client. And once the solicitor is instructed by a client, and that solicitor issues a writ on behalf of his client, the client has become a party to the proceedings, and he is represented by his solicitor in those proceedings. And there is no difference between that.
So you say the point of this is that the Indonesia can't just go to any solicitor. They have to instruct the Attorney General if they want to bring these proceedings, perhaps because the Attorney General, unlike an ordinary solicitor, brings to bear in deciding whether to accept the instructions some kind of public duty filter as to whether this is an appropriate case in which he should accept instructions. Whereas an ordinary solicitor will say, fine, this is my hourly rate, if you want to come to court, great, it doesn't matter to me whether you've got a good case or a bad case or whether it's a good idea or not. This is aimed at providing some kind of filtering, but it's the same as a state instructing any solicitor to appear in any proceedings. Is that
The Attorney General is a party to the proceedings and has to be.
The position of the Attorney General is quite an unusual one in this present situation, in that the Attorney General himself always traditionally was responsible for costs in these proceedings. And it's only when the law was changed in 2019 that it was conferred, immunity from costs was conferred upon him in certain circumstances. The Court of Appeal held that in this very case, under appeal, but this part of the appeal was, this matter wasn't pursued to appeal here, the Court of Appeal held that the immunity provision did not protect the Attorney General because the relevant case had begun too early and it wasn't retrospective in effect.
And the answer to my Lord Hamlin's question is the Attorney General has to be a part of the proceedings.
Well,
It's not like a solicitor.
he is, but he's there as well on behalf of the government that he represents. And we do not... the word represented by, the words represented by are the words of the regulations themselves. They are, it's not a formula that we have adopted to describe the proceedings, it's the wording of the regulation. So our submission...
Do you say the proceedings are misnamed? I mean, it should say State of Indonesia is the party on the documents, according to you, should it?
I don't say it's misnamed. The wording of Article 16 justifies the title of the proceedings, but the regulation authoritatively defines the status of the attorney in the proceedings. He is a representative of the government of Indonesia, and he has, under Regulation 6.2, the authority of the government of Indonesia to act on that government's behalf. Now, I don't think I'm going too far when I say this. If language like this were employed in relation to an ordinary client going to an ordinary solicitor, there would be no question whatever about the responsibility of the client for the conduct of the litigation. He would be answerable because he has instructed a solicitor to act on his behalf. And I do pose this question, and I don't mean this facetiously. We've raised this both with the Court of Appeal and now in the written case here. The Attorney General is in our submission, advancing a very difficult proposition for himself. Either he accepts that he is duly authorised to appear on behalf of Indonesia, or he does not. If he does not, he has not the authority to be here at all. And the proceedings would be an abuse of process under the rule in Young and Toynbee. There would be litigation conducted without authority. If he has authority, there is no problem. The proceedings are perfectly properly constituted. If he has authority, however, on behalf of Indonesia, then Indonesia is a party to the proceedings which he has commenced on its behalf. There is
If a solicitor brought proceedings and put his own name on the claim form, it'd be struck out.
In an ordinary case, that's so, yes.
Well, why not here on your theory of the case?
Hallowed by Jersey tradition, hallowed by the fact that Article 16 says that the proceedings should be brought on behalf of the Attorney General, on behalf of the government of Indonesia.
Well, it does say by or on behalf of.
Yes.
At the time when the attorney, before the immunity as to costs,
Yes.
was there anything public as to the ability of the attorney, or the regularity with which the attorney recovered any party and party costs from the requesting state. I think we saw that they're entitled to deduct. Is the attorney entitled to deduct his costs before putting the money into the fund or before handing it over?
I think so. From the recovered money, we saw that.
Yes.
It's Article 20 about
Yeah.
as to what's
But
to happen.
when this immunity from costs was brought in, was there anything said about what effect that had?
No, there wasn't.
On
And that's
the-
why the Court of Appeal had to sort it out. And it, by application of traditional principles, said that since the law took away an accrued right, if the law were given retrospective effect, it would be contrary to all principles that retrospective effect should not be allowed so as to deny an accrued right. And once the litigation began, the attorney exposed himself to the costs. And so to give retrospective effect would be wrong, and that's not been appealed.
I think Article 20 concerns the Viscount's fees and expenses,
Oh, yes.
not the Attorney General.
Yes, yes. There isn't a Article 20 deals with the with what is to happen to the money that comes in. It doesn't make provision for the Attorney General. As far as I am aware, and Mr. Hanson knows more about this than I do. As far as I am aware, it was simply accepted as practice in Jersey until the immunity law came in that the attorney paid the costs if he lost the case, subject, of course, to usual discretions. O'Brien is the...
And you got cost orders in this case?
We, on many occasions.
Right, and
Going back.
whether the attorney goes to Indonesia and says, right, well, this is for you, please, we don't know. We don't know whether the attorney recovers the cost that he's ordered to pay.
We don't know what the arrangements are between the attorney and Indonesia. But what...
You can have a situation where both agent and principal are liable.
Yes, of course. And one does have these anomalous situations. I seem to remember, as a matter of commercial law, before about 1953, both the overseas principal and the UK agent could be liable. And I think it was a case called Tehran Europe that changed all of that. This is in that sort of anomalous category, that the origin of which perhaps has been lost in the mists of time. But
Why doesn't 16.1 say that an application can be made by the requesting state, provided they get authority from the Attorney General?
well, my lord, I can't answer that. This was the language chosen by the Jersey legislature at the time of the enactment. It quite clearly involved imposing a role on the attorney because of his public law functions. And it was not open to the government of Indonesia under this scheme simply to go to any firm of advocates in Jersey and say, please represent us in these matters. They have to go to the attorney so that he can act as a filter. And
In a certain sense, the attorney is representing the interests of the state. And one could read Regulation 6.1, page 2109, as emphasising, in fact, that the state can't just go to the courts itself.
Yes.
It has to act through the
yes,
attorney. But that might be taken to indicate that it is, in fact, the case that the attorney is acting in and on his own behalf. He's got to be clothed with authority from the state, but that the attorney is acting on his own behalf. The state cannot act on its own behalf, and so that he is not acting as if he were a solicitor or ordinary lawyer for the state, that one reads the words represented by the Attorney General in the sense of representing the state's interests, not representing them as a person bringing proceedings in the court.
but my lord, it's the final words of paragraph 2 of 6 that's rather important on 2109. constitute the authority of the government of that country or territory for the Attorney General to act on the government's behalf. So, in acting...
But forgive me, shouldn't one read that in the context of 6.1? So 6.1 sets up the concept of representation by the Attorney General. And then you need, and indeed Article 16.1 itself makes it clear that for the purposes of the Attorney General himself to act, there needs to be a process of clothing him with authority on behalf of the state to play that role. But that begs the question, what role is he going to play?
Well, as the representative in court of the Indonesian government. That is what he is there to do. And indeed, I could take you to an earlier judgment. Mr. Hanson may recall which one it was because he appeared in the case. There is a judgment, I think, of Sir Michael Burt in about 2014 in which he specifically says that counsel, whose name I'm afraid I now forget, it's probably Mr. Bellum, appeared on behalf of the government of Indonesia. I'll see if Mr. Hanson can find that. It all
depends on what you mean by on behalf of, doesn't it? Well, and you say it means the same as a barrister or solicitor acting for an ordinary client. And I think Mr. Thompson says, no, it doesn't mean that. And that he says, you can tell it doesn't mean that because that would be contrary to the spirit of the convention and also appears to be inconsistent with analogous situations in those other cases that he showed us.
My lady, the conventions don't say that there is to be any kind of there is any obligation to introduce costs protections in respect of proceedings of this kind. When the whole point, the conventions frequently are drafted on the basis that the proceedings are to be brought during and in accordance with the ordinary domestic laws of the countries in which they are brought. And of course, if the proceedings are brought in Jersey, they're brought in a cost-bearing jurisdiction where the losing party would expect to pay the costs.
But your reliance on this is not purely in relation to costs. If you're right, and Indonesia has waived its jurisdiction, has waived its immunity, then that's presumably for all purposes.
Yes, it would be. Yes, I absolutely agree about that. Well, it would be at least for all purposes connected with these proceedings.
Yes, of course.
Because some of the cases that my friend was relying on are readily distinguishable, because what was happening is that the plaintiff in the relevant jurisdiction, the United States or Canada or Australia, was trying to use the fact that extradition proceedings had been brought as a general waiver in respect of claims of tort. But of course, that wasn't going to succeed. We're not arguing for that. We're saying that here is the attorney representing the government of Indonesia in these proceedings, and it's in these proceedings the costs are sought. And we're not saying that's some sort of general waiver of immunity that would then enable Mr. Tantular or anybody else to start issuing tort claims against the government of Indonesia. I've made the submissions I want to on representative authority. Could I move on to deal with some of the other points that Mr. Thompson has made? The case of Propend and Singh, deal with this, I think, fairly shortly. There was no provision in Propend and Singh anywhere near in corresponding to the provisions we've just been looking at in Article 16 or Regulation 6 and 7, Regulations 5 and 6, as to representation. Also in this case, of course, we rely upon the conduct of Mr. Kayo. I'll come back to that later, so that's another reason that we rely upon for distinguishing Mr. Kayo Mazar, I think, in the in the proceedings.
Sorry, so he's the deponent, is that
He
right?
is
Or what conduct?
he is the official of the ministry in Indonesia. So we rely on his conduct as well. And I must come back to that because it is a separate basis of liability, of course, in terms of submitting to the jurisdiction. Now, could I then...
Did he have knowledge? Is there a finding that he had knowledge and authority?
No, there isn't, but his own evidence asserts that he has authority. His own evidence discloses that he is a high official in the ministry. His evidence discloses that he liaised with the Indonesian Attorney General in connection with these very proceedings.
Is there a finding or evidence that he was aware that he was waiving his privilege? Have to have knowledge of the privilege before.
Well, my Lord, there is no finding by the Court of Appeal to that effect because they dealt with the matter. They were perfectly satisfied on the basis of the representation point. Yes, thank you.
If you're wrong on representation, you're saying his actions in themselves.
Yes, and I'll come to the evidence in a moment, if I may. Could I just deal with a couple of the other cases on which my friend relied upon first? Blaxland, a United States case, was an extradition case. Now, extradition cases are in a completely different category for reasons explained by the learned judge in Blaxland, which you will find at 2539.
An extradition is a request to the state.
Yes. The critical passage is in paragraph 11 of the judgment of the United States Court of Appeals, where the court said...
Page?
I'm sorry, 2548.
Thank you. Yes.
Unlike a letter rogatory, which is a direct court-to-court request, extradition is a diplomatic process carried out through the powers of the executive, not the judicial branch. See Lopez and Smith and Hood. Extradition is a matter of foreign policy, entirely within the discretion of the executive branch, except to the extent that a statute interposes a judicial function. Martin and Warden. Extradition is an executive, not a judicial function. The power to extradite derives from the President's power to conduct foreign affairs. Thus, the nation seeking extradition does not directly contact the courts of the requested country. Rather, the foreign government makes its extradition request to the US Department of State. After the request has been evaluated by the State Department to determine whether it is within the scope of the relevant extradition treaty, a United States attorney, if so instructed, files a complaint in federal district court seeking an arrest warrant for the person sought to be extradited. Thus, all extradition-related judicial proceedings are initiated and conducted by the US Department of Justice. The executive branch conducts the procedure on behalf of the foreign sovereign. The foreign sovereign makes no direct request of our courts, and its contacts with the judiciary are mediated by the executive branch. That is simply not the position here in the light of the... Well, we submit it's not, in the light of Article 16 and Regulations 5 and 6.
Sorry, just to point out, I mean, one sees the court there using the language, conducts the procedure on behalf of the foreign sovereign. I mean,
Yes.
That's reflecting the fact that it's the foreign sovereign that has the interest.
Yes.
And so, in a certain sense, there isn't acting on behalf of the foreign sovereign, but it's nonetheless the state attorney that is actually the party to the proceedings.
My Lord, that is certainly the case. But this language...
Sorry, just to make the point, I mean, there's the issue, as it seems to me, is whether the language used in Article 16.1, that the Attorney General acts on behalf of the government of a country, is being used essentially in the same sense that that language is used in this authority.
My Lord, if it stopped there, yes, but it doesn't. I'm sorry, I'm going to be repeating myself if I go back to Articles 5 and 6.
All right, yeah, that's your answer to...
Yes, it doesn't stop there, is what we say. The Schreiber case in Canada is very much the same point, as is von Arnim. They're all extradition cases. And there are cases where von Arnim is a good example of this. You have in that case an attempt to gain leverage through the fact that the extradition proceedings to start other proceedings against the government that sought extradition within the jurisdiction of Australia. So in our submission, that doesn't assist. In the Yemen case that my friend took you to a few minutes ago, we deal with it in paragraph 47 of our case, if you want the reference. But it's in the Yemen case, it was held that instructing a solicitor to bring proceedings could amount to a waiver of jurisdiction, provided that it were done by somebody who had sufficient authority to instruct the initiation of proceedings. Well, here we have the Indonesian ministry by a high official doing so, but a high official who's been in touch with its own Attorney General, and a high official who then lodges an affidavit with the Royal Court to the effect that I will come to in just a moment. We don't say, dealing with another point here, we don't say that simply appearing as a witness or filing an affidavit amounts to a waiver of authority. There is clear the decision of Sir Robert McGarry on this in an interesting case about clergymen's collars. That's the Whipple case. It really is most instructive about how collars were redesigned in the 1950s. In that case, all that happened was that the person from the business concerned appeared as a witness. He didn't take any active part in the proceedings other than giving evidence. He didn't ask the court to make any particular orders. He wasn't giving instructions. He wasn't having meetings with the lawyers who were going to be conducting the case in court as to what he wanted them to seek. Now, when we come to look at the evidence of Mr. Muzar, we see something really rather different, and you'll find that at page 616. Quite a long affidavit. It's dated the 16th of May. So you'll see the date at the end of the affidavit. It's the 16th of May 2019. An affidavit of Kayo Rahelian Muzar, the Ministry of Law and Human Rights in Jakarta. Could I just draw attention actually to the no, I don't. Yes, I'll move on through the affidavit towards the conclusion of the affidavit. He says in this document that, at paragraph 32, he's going to give a brief update on the SEZI, and he explains the background with the Indonesian proceedings, and then he says, at the very end of his affidavit, in light of the paragraph 43.
Page number.
Oh, I do apologize. 628.
Thank you.
In light of the above evidence, I request on behalf of the Government of Indonesia that the Royal Court refuse to declare that the SEZI judiciaire do not prevent the proposed assignments to Mr. Koswara, and moreover that the Royal Court refused to vary the SEZI judiciaire to permit such assignments. There's a specific request by him for that to be done. He also describes in this affidavit how he went to Forgive me one moment, I think I may have given you the wrong page reference for this particular item. There's an earlier affidavit at page 263 in the same bundle. No, there is not, I'm afraid. I've given you the wrong reference there. There is an earlier affidavit as well.
It's in the supplemental.
It's in the supplemental record. I'm grateful. 263 in the supplemental record. This is an affidavit of the 15th of September 2014. And this is also an affidavit of Mr. Mazar, and he explains in this affidavit that in connection with these very proceedings, he went to Jersey in August 2014, and if you look at paragraph 42, you will see that in connection
help us with the page
271 in the supplemental bundle.
Thank you. Yeah.
He says, I telephoned the Indonesian Attorney General during the early hours of the morning. A discussion took place during which the attorney indicated his consent to a supplementary request for assistance being signed and submitted to the Jersey's Attorney General based on 210 proceedings. So he's been engaged in this case with the Attorney General of Indonesia. He is, as he describes himself in paragraph 1 of this affidavit, the Director for International Law and Central Authority in the Ministry, and he's authorised to make the affirmation. Now, when this case came before the Court of Appeal and costs were sought, Mr. Hanson relied on these two affidavits. There was nothing at all to stop the Indonesian Ministry, or indeed Mr. Mazar, from filing evidence on his own behalf or on behalf of his government. The Indonesian government has filed no evidence at all to say that this application or this involvement was made without its authority.
So this is a respondent's notice point, effectively, is it?
It is, yes. Yes, and Mr. Mazar's letters of request also appear. The letters of request also show Mr. Mazar as the point of contact in Indonesia for dealing with these matters.
Do you have the bundle references?
I'll ask Mr. Hanson.
One of them's at 957. So the request is from the Minister to the Attorney General.
Yes, I'm grateful. So we submit that what we see here is not somebody, a low-level official participating in proceedings, but an official at the highest level in communication with officials in the government. It is unreal to suppose that the government of Indonesia did not knowingly participate in these proceedings. It was dealing with the senior advocate of Jersey, the Attorney General. And it is, in our submission, unreal to suppose that it did not realise what the implications of starting these proceedings were. There is no suggestion on behalf of the government of Indonesia in any evidence that it did not appreciate that it was, by participating, waiving immunity. So, my lords, our submission, my lord, my lady, I do apologise, our submission is that in this case there is ample material for saying that the Indonesian government has initiated the proceedings and therefore it waived immunity, and that after the proceedings had begun, it affirmed the proceedings through a high-level official in conjunction with its own attorney by inviting the court to make orders in the way that Mr. Mazar did. He did not simply appear as a witness. He gave evidence in which he asked for particular courses of conduct to be taken. He liaised closely with lawyers in Jersey, and he liaised with his own legal team, none less than the Attorney General at home. And he put in his point of contact in Jakarta in the letter of request. I don't know if Mr. Hanson's managed to find the letter. I think he's still searching.
And the reason why this has only cropped up now is because of the immunity that has recently been conferred on the attorney.
Yes. Yes. If the law had not changed, this point would not have come up.
Can I take you back to the extradition analogy, or you say it's no analogy because it's a matter of foreign relations between states, and then it's the state receiving the request that there's then a judicial process within its law.
Yes.
Could it not be said that the position is in fact analogous here, where the request is made under, if not strictly the Palermo Convention, because it wasn't enforced for Jersey, we're told, but it was treated as if it were under that, where the provisions do provide, don't they, for affording assistance by one state to another. And it's then a matter for the state that receives that request in a diplomatic capacity, or foreign relations capacity, to use its own judicial system to carry out that request. What do you say about that suggestion?
It's up to Jersey how it puts into effect the procedures which are to be adopted. And Jersey has chosen to bring this about by appointing the Attorney General to act as the representative of the state of Indonesia. The extradition proceedings are not constructed in that way, whether in the United States, where we have an indication as to how they're conducted in the judgment in Blaxland, or as far as I'm aware, in this country, where a request is made to the Home Office and the Home Office then brings the proceeding. The Home Office doesn't say, the relevant legislation doesn't say it shall be the government of the foreign state shall be represented by the Attorney General, whether in the United States or in the UK. But this legislation is constructed differently, and it's within, I would submit, the authority of the States of Jersey Assembly to decide how the legislation is to be conducted. There is nothing in the conventions which says that it must be done in some other way, or that it must be done in such a way that no costs are incurred, no costs liabilities are incurred by the requesting state.
There is a provision that says that the ordinary costs of executing a request shall be borne by the requested state party.
There are indeed, but those, I would submit, mean own party costs rather than effectively operating as though the requested state is to be an insurer in respect of the liabilities incurred by the requesting state. So its own party costs, yes. The Attorney General for Jersey can't submit a bill of costs to Indonesia, but when it comes to Indonesia's own costs, Indonesia's liability for costs, if an order is made, Indonesia must answer those itself. Could I give you the reference to the letter of request, please? It's page 964.
In which of the two bundles?
In the main electronic bundle.
And I'm sorry, I didn't note the number now.
964.
Thank you very much.
And the contact number given is that of Mr. Mazar.
Could you just help me then with how affidavits are actually physically filed in Jersey? Presumably, Mr. Mazar would have sent his affidavit off to the Attorney General's office, and somebody in that office then would have made a decision as to whether to put it into court or not.
Yes, that must have been done.
Yeah, which is a distinction between a party to an action. They don't have to go through the Attorney General. They can just put in whatever evidence they want.
My Lord, it's, in practical terms, I would say that no different from what would happen in an ordinary solicitor-client situation. A party can create a witness statement or affidavit, but they would normally hand it to their legal representative to file it.
But the Attorney General in this case would have the option to not to file it at all if he didn't agree with it.
Well, he would probably regard himself as obliged to consider whether he should file it, because of he's wearing two hats. As attorneys general often find themselves doing. But he would certainly, as an officer of justice in Jersey, have to consider whether it was appropriate to file it. But he was clearly requested by Indonesia to do so. And when he filed it, as I'm sure you could imagine I'm going to submit, he did so with the authority of the Indonesian government. Could I just check that those either side of me don't have anything more that they want me to say? Certainly. My Lords, I wonder if Mr. Smith could follow on this point, because...
Well, I'm afraid, unless you can do it within 1 minute.
I think he probably can.
All right, if it's 1 minute.
Yeah, my Lords, my Lady, if you pick up electronic bundle at 5820, this is, you may have already looked at this, it's the statutory provision in the United States which allows for enforcement of foreign judgments. It's section 2467, it's in title 28 of the United States Code. And if you look at that page, my Lords and Lady, you should see there's a definitional section of foreign nations having access, and then over the page, in the middle of the page at C, jurisdiction and venue, and the words, if the Attorney General or the designee of the Attorney General certifies a request under subsection B, the United States may file an application on behalf of the foreign nation. Now, I would now ask you to turn to page 5606, which is the start of a congressional report. It's a report described as a report of the Committee of the Judiciary in the US House of Representatives. It's dated the 30th of October 1997. And I'll ask you to go to page 5615. And you will see there, under section 10, sec 10, a reference to section 2466. Well, in fact, that became 2467. And that's just a recitation of what was then the draft of that section. And so this report is dealing with that. And then if one turns to 5658 in this report.
5658.
Yes, correct, my lord. Towards the bottom of that page, again, picking up the reference to section 10, enforcement of foreign forfeiture judgment. It deals with a description there of what the purpose of it, which is to put into effect the Vienna Convention and so on. And I'd ask you to go to the bottom of the next page, or towards the bottom of the next page, to the, I think, penultimate paragraph starting, the proposed statute is intended to reinforce, and read that passage.
So, sorry, what are we to take out of that? This
Pick
seems to
out,
be
yes.
a different form of legal procedure which the US have. Is that right? They seem to say that for this sort of confiscation order, the way forward is this right? The foreign states.
Look at it should on page 5659, the fourth paragraph down. Starts, the proposed statute is intended to reinforce our compliance with Vienna Convention, starts like that.
Yes.
And goes on to say, as the party requesting assistance would file a civil action as a plaintiff. So it's the government of the foreign nation that files a civil action as a plaintiff. And then goes on to say...
Sorry, what do we take from that? Because this is a different regime.
The different regime.
It's very clear that the government is itself the party. What's an issue in our case is whether the government is a party.
Yes. What this explanation goes on to say here is that the United States Department of Justice can screen out requests, and it will act as the representative of the government. But the point I wish to make was that it's essentially the same kind of situation. It's filtered by the United States Department of Justice, but it's acting on behalf of a government. So we're not dealing with an alien.
No, sorry. For the civil action, it's the government itself acts as the plaintiff, doesn't it? That's what it says.
Yes, but by and through the Department of Justice. So it has this special sort of filtering.
But are you saying this is one way of implementing a treaty in similar terms to the Palermo Treaty? Or is it not that? Which is the Vienna Convention?
The Vienna Convention was the 1988 one in relation to drug trafficking.
So you're saying that doing it like this is not regarded under the Vienna Convention as some incursion into the sovereignty of the requesting state?
I think it just serves as a good illustration of how this kind of operation of acting on behalf of a foreign government is accepted on the international scene, and if the United States accepts that this is a methodology by which a foreign government will be represented by the US, it's very similar, in my submission, to the position we have in relation to Jersey, where it represents the government of the foreign nation, but it does it in its own fashion and filters whether or not it will bring the claim to registered foreign judgment.
Yes.
The fundamental difference is that the foreign country actually initiates the civil proceedings. Have I picked it up right? I'm sorry for being slow. 5615.
5615 is, let me just get back to that.
No, I don't know.
I don't believe so. I think it's, the provision I referred to earlier on was the section number 2467 itself, which actually...
Well, it says that on the page my Lord referred to at the bottom, under jurisdiction and venue, where the Attorney General or their designee certifies a request, the foreign nation may file a civil proceeding in the United States District Court.
And then below that, at paragraph 2, it says the United States shall be the applicant. It's the applicant on behalf of the foreign government.
Well, it says in such a proceeding, the foreign nation shall be the plaintiff.
goes on to say that the United States shall be the applicant,
Is it over the page or where?
which is under paragraph 2A.
Sorry, 2A, where are you?
I'm now on page 5821, which is the...
Well, sorry, before we move away from 5615, that 5615 at the bottom of the page seems to be saying that it's the foreign state itself, the foreign nation shall be the plaintiff. That doesn't say that the US government is the plaintiff. You now want us to look somewhere else?
I don't see, so it's 5615
At the bottom, under jurisdiction and venue. In such a proceeding, the foreign nation shall be the plaintiff. Then it talks about venue. And that seemed to reflect what I was asking you about on the other page, 5658, which also said that the state is itself the plaintiff, i.e. the party.
But acting through the Department of Justice as the applicant.
Well, what's the relationship between the page at 5821 and the page at 5615?
5821.
Yes, that's what you were looking at. C1.
That's what says, oh yes, the United States will be the applicant.
58, is it?
Yes.
But I don't understand what the relationship between this provision is and what you were showing us before.
This 5821 says the United States shall be the applicant and the United States may file an application, and the other one said the foreign state shall be the plaintiff and may file proceedings.
And then 5658 says exactly the same.
The provision that was enacted is the first one that I took you to, which was at 5820. The congressional report was dealing with the drafts of what then became that section number.
Right. You probably assisted as much as you can.
Yes, I think so.
On this very dense document at this stage, and I think Mr. Thompson needs to have his opportunity to reply. Thank you. Yes, Mr. Thompson.
Very briefly, my lady. The issue of the witness, 2 points on that. I couldn't find the reference when I was on my feet, but may I take you to page 3412, the electronic bundle. First of all, this is the United Nations Convention on Immunities of States, 2004, I think it is. This is Article 8, which sets out the international practice. Now, the first 2 points are familiar to us because they're covered by the State Immunity Act, but it's 3 that is important for these purposes. The appearance of a representative of a state before a court of another state as a witness shall not be interpreted as consent by the former state to the exercise of jurisdiction by the court. Now, my learned friend, of course, has relied on the affidavits that were filed in the proceedings as evidence as time went on, but there are 2 issues which arise from that. First of all, the mere fact that someone's authorised on behalf of a state to file evidence does not waive state immunity. It can only be waived, first of all, by someone with knowledge of the right that is going to be waived. That's the first thing. And secondly, the express authority of someone within the state. There is no room, as my learned friend in my respectful submission started to come to, for some sort of ostensible.
Are you suggesting that Mr. Mustar was on some kind of frolic of his own and that he was doing this?
No, he's doing it in the interest and on behalf of the state. He provides the evidence, but the convention says if you, as a representative of a state, merely are called as a witness, that's not sufficient.
If as a matter of law we decide what he has done does amount to a submission of the jurisdiction, then the fact that the state didn't realise that that was the legal effect of what they were doing. That can't be what it's referred to.
No, it is. Yes. Yes. I take you to the passage. It's in the case we looked at earlier, as is 3119 is the where it starts. I'm sorry, I shall try and just refer you to the passages. The preamble's at the very top of paragraph 56. This is where this issue about taking a step in the proceedings is important. Section 2.3 should, however, be read in the light of authority of long standing, establishing the importance of state immunity and the importance of it not being waived except with appropriate authority. That's the point. That's a point that's made in Propend as well. And then he goes on to say, in this instant case, the fact that the step in the proceedings alleged to constitute the waiver is taken by solicitors instructed by the embassy does not conclude the matter. A solicitor acting without authority cannot waive the immunity. And then he goes on. The next passage is at 58. And this is why I'm drawing this to the court's attention. I do not consider that the doctrine of ostensible authority applies either to the solicitor or to Mr. Al-Qaeda, or that jurisdiction can be created by an estoppel. The state has protection against unauthorized action taken by a solicitor or a member of the mission. So that's the point I was making. For state immunity, because it's regarded as so fundamental and so important, there has to be express authority in the person who, it is said, waived the immunity.
So you're saying that this person had no authority to make this request for?
If you take two issues. We say that the mere fact that you make a request for assistance does not waive state immunity. Now, that's an issue that the court will have to look at and decide. But on our case, no, it doesn't waive state immunity merely because you make a request. Secondly, if you are saying that, well, it has waived state immunity, the person waiving the immunity has to be clothed with the appropriate knowledge and the authority to waive it. And that's what this case in over the page said, which we looked at. Sorry, we have to go backwards for this. I'll just give you the reference. It's Lord Justice Jenkins. And .3115 is where the passages are. Because what happened in that case was that the person concerned, the Spanish person, had instructed solicitors, had entered an appearance, and had actually taken part and applied for security for costs. But all that was done without the knowledge of the principal, and therefore it could not amount to a waiver. That's the issue that's been dealt with there. So here. So it goes back to this case of in 1957. So my submission is that what's been put before you in itself is insufficient to waive that state immunity.
Where does section 2.5 fit into this, which says that, I'm looking at, you quoted it in your case on 1709, that the deemed submission, if a state has intervened or taken a step, does not apply to any step taken by the state in ignorance of facts entitling it to immunity, if those facts could not reasonably have been ascertained and immunity is claimed as soon as reasonably practicable. That looks as though you can only plead ignorance if you couldn't reasonably have known what the position was and you claimed immunity as soon as you found out.
Well, on that issue, the issue of state immunity didn't arise till the Court of Appeal and Costs. The moment it did, it was claimed.
But are you relying on 5? Are you saying that if there was a step taken, it was done in ignorance of facts entitling the state to immunity?
Difficult to say because we haven't got the evidence. That's the problem. But what the cases do say, and we've been through them, is that the person who is said to have been made the waiver has to have the requisite authority and the knowledge of the right to be waived, and there's no evidence of that in this case. Anyway, I think our submissions are fairly clearly defined on the side. That's my point I wish to make in reply.
Yes, thank you very much, Mr. Thompson. The board are very grateful to all counsel and the teams of lawyers that have assisted them in preparing for this case. The board will now take time to consider what advice they humbly tender to His Majesty. These proceedings are adjourned. Thank you very much.
Would it be possible in this case for written submissions about costs to be deferred until after the judgments have been?
Yes, in fact, it's the usual practice of the board to defer. You're quite right to raise it.
I understood that, but I thought from the directions that it was appropriate to raise it now.
Yes, but you're quite right.
We haven't done anticipatory submissions on costs.
No.
I'm grateful.
All right. We'll adjourn now. Thank you again for your assistance.